What is an executor's bond? Why do I have to have it? And where do I even go? Hey there, my name is Ron Payne. I'm the CEO and managing partner here at Payne Law in Kernersville, North Carolina, where we focus on estate planning, probate, estate administration, and family law. And today I wanted to talk a little bit about when a bond is required, what is a bond, and what do all these things even mean. So if you're handling the estate of a loved one and you go to the clerk of court and they hand you that big packet of paper, and then you go back and you think you've got it, and they say, well, hold on a minute, you've got to do a bond. And you say, well, what's that? And they say, I don't know, I'm not a lawyer, I can't give legal advice, you'll need to contact an attorney for that. So I just wanted to share a few things about what it is, how do you get one, what's it cover, and that sort of thing. So first, a bond it's a little bit like a jail bond, but obviously you're not in trouble, you're not going to jail. What it is to make sure that the estate is properly administered in certain cases, and I'll talk about when you need a bond, because not every estate requires a bond. But when a bond is required, it's to make sure that the executor honors the law of North Carolina and takes care of everything in the proper order. And so, for example, if creditors or if heirs don't receive their money because the executor mishandles or misapplies the law in North Carolina, then that bond can be used to satisfy the policy. It's just there to make sure that the executor does follow through with the duty and doesn't just open the estate checking account and run out of there. And that bond is normally 125% of the value of the property. So, for example, if you've got a bond or a estate in North Carolina and the property is worth $100,000, then your bond amount would be $125,000 plus or minus. What that means is you're going to basically reach out to a bondsman and they're going to insure you with a bond that you will, do your job and then take care of everything. And so what happens is you would reach out to us here at Payne Law or, your local estate planning attorney if you're not local. And if a bond is needed, as part of us preparing your application process, we're going to reach out to bond agents and help find out what's available to you. Now, bonds are a little bit weird. If you are required to have one, it's based on your personal credit. So if you have higher credit, then they deem you, rightfully or wrongfully, less likely to run off with everything, and so the bond might be a little bit cheaper. And if you've got a lower credit score, that doesn't mean you can't get qualified, but it does mean the bond might be a little bit more expensive. It's a risk assessment, if you will, a little bit like driver's insurance and that sort of thing. And we do have situations where bond companies will sometimes refuse to issue a bond if the person's credit history, etc., is too risky. And if that circumstance, we'll help look at alternative options and see what we can do. And it may mean that we have to find somebody else in the family to be the executor. It may mean that we need to look at alternative routes with the clerk of court. We'll just have to look into those things and see. So so I have to get a bond and I know I need to reach out to a bond agent, but when do I even have to have one? First, when do you not have to have one? If you're in North Carolina and there was a will and the will says you're the executor and you don't have to pay bond, then no bond for you. But if you're the executor and you live out of state law says you still have to have a bond, even though the will says no bond shall be required of my personal representative. State law overrides that. So if you don't live in North Carolina, you would have to have a bond. And the second time you would have one is if there is no will, then you would need to have a bond because there's nobody appointed executor. So everybody else has to have a bond. If you're not named in the will, the bond is waived and you live in state, everybody has to have a bond. And so all you would need to do is reach out to us. We'd get that process started. It's pretty simple, actually. They basically run, a slight credit check. You fill out the application, and it comes back within, at most, a day or two. And we can work on that while we're working on your application. So it really doesn't hold things back. But the clerk of court will not issue the letters testamentary or the letters of administration if there's not a will, if we don't have that bond in place, if it's required by state law. So if you're running an estate and you see this stuff about bond and you're not sure if a bond is required in your estate, or you need to talk with somebody about how to get a bond, we work with in-state, out-of-state executors all the time throughout North Carolina, and we would be honored to assist you. Reach out to us on our website at applepainelaw.com or give us a call at 336-281-6928. The team here at Payne Law focuses on helping families navigate life's important decisions, and we are honored to help take care of you during the loss of a loved one. We will care for you and your family just like you are our own, and do our very best to help guide you quickly and efficiently through the North Carolina probate process. I hope this has been helpful. Until next time, like and subscribe here on YouTube. Take care and have a great day.